Hello and welcome to Rights and Recourse, a program that tackles issues affecting your rights and matters of legal recourse. My name is Dumile Mateza. Remember, you can also be part of our discussion today by tweeting us at Rights Recourse or calling our studio line on 011 714 5497 or 5498. Alternatively, email your thoughts to Rights and Recourse at sabc.co.za. The 1913 Land Act has haunted South Africans for over a century and continues to this day. The promulgation of the Spatial Planning and Land Use Management Act on July the 1st has pitted both the traditional leaders and the protagonists of the values of the Constitution against the Act. The Act aims to develop a new framework to regulate planning permissions for approvals, sets perimeters for new developments, and provides clarity on how planning law interacts with other policies of government. Today on Rights and Recourse, we explore the issue by looking at the constitutionality of both the Act and the role of the traditional leaders in as far as this is concerned. To unpack today's topic are Dr. Nozizwa Makhalimela, Deputy Director General for Spatial Planning and Land Use Management from the Department of Rural Development and Land Reform. We'd also like to welcome Ms. Nomboliso Gasa, who will join us later, researcher on gender, land and customary law. In our Cape Town studio, we are joined by Dr. Aninka Classes, Director of the Rural Women's Action Research Program from the University of Cape Town Centre for Law and Society. And from East London, we're expected to be joined on the line by Mr. Siabulela Manona, who is a town planner. We had also invited the National House of Traditional Leaders, but they unfortunately could not confirm their participation until now. Ladies and gentlemen, good afternoon and welcome to Rights and Recourse. I'm hoping Ms. Gasa will join us later, but Dr. Makhalimela, could you explain to us what is the real issues around the Spatial Planning and Land Use Management Act?
Good afternoon, Mr. Mateza, and good afternoon to your listeners. I don't know if there are any issues with the Act itself. The Act was promulgated, as you said in your introduction, on the 1st of July by the President of the country as a piece of legislation that will redress past imbalances. And as we know, we're coming from the apartheid era, whereby legislation used to be done, promulgated, and implemented in accordance with the different racial groupings. This act says we are all the same, we are all equal before the law, and that planning and development should take place the same way and equally across all racial groupings.
Was the tension between traditional leadership and municipalities in terms of planning around, I would imagine a municipality that is a district municipality would plan, and part of that plan will include a rural area that is under a traditional leader?
What the Act provides for in Section 23(2), it says that when municipalities, which are the authorities of first instance where it comes to municipal planning, that it should incorporate the participation of traditional leaders, particularly because the traditional leaders are taken as de facto authority in those areas and owners of that property in rural areas.
De facto, that's a very difficult problem. De facto owners of the property, somebody might disagree with you.
That is how they are recognized, and I believe that is how also they are recognized in the Republic and maybe even by our Constitution, which is why I was saying it's either that or they are custodians of the land under the traditional authority or council, and therefore they assist municipalities in leadership and also on issues related to land.
Let me go to Cape Town. Dr. Aninga Claessens, is that how you understand this piece of legislation to mean?
I think the piece of legislation is a good piece of legislation because, as the doctor has said, it repeals some of the old homeland approaches and approaches that apply differently to black and white people. I think, I have a fundamental problem with her saying that traditional leaders are recognized as the de facto owners of the land. That isn't in the Constitution, nor is it in any law. The Constitution recognizes traditional leaders according to customary law. And so the big issue is, who does customary law regard as the owners of the land? And I think if you ask many, many rural people who owns the land that they've inherited over generations and invested in, they would say their families own it. Plus, there's been a lot of law in the past recognizing that the reason that black people didn't have ownership rights was racially discriminatory. And so there was law even under the previous government in 1992 called the Upgrading of Land Tenure Rights Act, which upgraded the land tenure rights of people living in the former homelands to ownership. There was also the Interim Protection of Informal Land Rights Act of 1996, which provides that ordinary people have rights to the land they occupy, use, and have access to, and that they can't be deprived of that land without their consent, except by expropriation. So I think there's pretty clear legal evidence that the ordinary people living in the former homelands are the de facto owners of that land. There was never, during even colonialism or apartheid, any construct that traditional leaders are the de facto owners of the land. And the White Paper on Land Reform of 1997 clearly states that the people who were dispossessed and dumped in the former Bantustans would have had ownership of that small area of land, but for discriminatory law. And the Constitution says anyone who is legally insecure because of past racially discriminatory laws is entitled to tenure security.
Earlier,
so it's really quite extraordinary to hear government now saying that traditional leaders are the de facto owners of the land and not the people.
Let me come back to something. We'll discuss that we're probably at another time. But I want to come back to something else that I raised earlier off air. And that is the issue of one of the problems in the planning. Somebody was saying to me earlier, no, not earlier, during the week, all planning that was done during the apartheid era, pre-1994, was thrown out of the window. And post-1994, there's been no planning. Is this piece of legislation intended to close that gap?
It isn't like there was no planning at all. There was planning, but as I said before as well, that it was applied, there was a lot of discrimination. In other words, different laws applied to different racial groupings. I just though want to respond to what has been said there in the Cape Town studio, that we are just recognizing the leadership of Amakosi as leaders of the people, that they have for quite some time taken the interest of the people. But this is not to say that we want to strip the individual families of their right to land. If anything, our department, this department, is taking care of that and ensuring that when we look at tenure issues, for example, that we restore back that dignity that the people lost in rural areas.
The other question for me, in our introduction, we spoke about the Act is aimed at regulating planning permissions for approvals. Who has to issue these approvals, if these permissions and approvals?
Okay, in terms of the constitutional court judgment that we had against one of the legislation that we're administering in the department, the Development Facilitation Act of 1995, the Constitutional Court found that this was unconstitutional because those powers and functions were given to provincial government. And it was found that no, municipalities, this is a function really that needed to be given to the municipalities who are now recognized as first authorities in terms of land development and planning.
There seems to have been, Aninka, Dr. Claessens, there seems to have been, I've been trying to pursue this line of talk, of discussion with Dr. Makhalimela here with me, the line that if rural or district municipalities want to implement their integrated development plans, then they have to include part of rural communities. They must then negotiate with a traditional leader in that rural communities, and that's where the problem seems to be coming in.
I think you had, very serious problems after 1994 when local government, it was agreed in the Constitution that local government throughout South Africa would be elected, would be through elected structures. And traditional leaders were very, very unhappy about that. They wanted to retain the kind of governance role that they had under the Bantustans, and they brought a challenge to the Constitution to say that they needed direct powers of governance, which they lost in the certification judgment. And in many areas there has been an unfortunate standoff that when local government wants to do development, traditional leaders have said you can't do that development because we own the land. Now the land is actually registered as owned by the government of the Republic of South Africa. And this issue has seriously complicated and stopped development. But as the doctor from the department says, it's quite clear from the Constitution that planning is a municipal function. And we have fantastic IDP provisions which require that the people affected by the planning should participate in it. Mm-hmm. So basically you do need interaction with the people for whom the development is going to, development is going to benefit. And a planning system like we have in the Constitution and is entrenched by SPLUMA supports that. The question then is who represents those people in that process? Can they represent themselves or must they be represented by traditional leaders? We think that you can have a combination of both. The real concern is that there's a law called the Traditional Leadership and Governance Framework Act that was enacted in 2003, and it recognizes the traditional leaders who were appointed during apartheid, and it takes the disputed tribal boundaries that were entrenched through the Bantu Authorities Act, despite massive opposition from the ANC, from Governor Mbeki, from Luthuli, from Madiba, as the boundaries of the current communities in the former homelands. And what that means is that in many instances, people who purchased land historically before the Land Act, or people who were on mission land, or people who had had clans, find themselves subject to imposed traditional leaders. And the problem is if those people get the authority, the sole authority to represent them, it cuts out ordinary people from participating in the planning process. So of course one needs a combination because in many areas traditional leaders are legitimate, but unfortunately we have a law that imposes them wall to wall throughout the former Bantustans on the basis of the disputed tribal boundaries created during the 1951 Bantu Authorities Act.
Well, we will continue with our discussion here on rights and recourse with this issue of spatial planning and land use management, and we will talk about that act at a later stage. It's another boiling pot, that act, the Frameworks Act, around traditional leaders. When we come back, we'll be joined by Nomoni Sokasa. Don't go away, we'll be back right after this.
The city of Durban and its surroundings is one that is filled with history and cultural diversity.
Durban is a natural paradise known for its gorgeous coastline of sun-kissed beaches and subtropical climate.
Flea markets are essential to visit if you want to experience Durban's Afro-Oriental atmosphere.
The city of Durban is an elegant, mature and ambitious city. The vendors at the Vic offer a range of African and Oriental products, an eclectic mix that is hard to resist.
That's Kaleidoscope, Sundays at 5:30 p.m. CAT.
Welcome back to Rights and Recourse as we discuss this topic around the Spatial Planning and Land Use Management Act, something we didn't have, and it is a issue where we thought we'll have the traditional leaders here today. They decided not to take part in this discussion, citing the fact that they'll be having another meeting with the minister and they don't want to jeopardize that. But the question I want to ask quickly, what prompted, I know you've given some of the reasons, what prompted government to promulgate this act, this little piece of legislation? There are many of these pieces of legislation that I looked at them yesterday, they are so confusing.
Thank you very much for that question. I think the main reason, one of the reasons that it has been promulgated is to address that very issue, that there have been many pieces of legislation talking to the same thing, to different sectors of our society, where now we are one country, one democratic country, which has also similar values. So we thought that we must then have this act passed so that it can apply the same way, equally, across the whole spectrum of government and of its citizens.
Let me go to East London, if you are there, Sebulela. Sebulela, earlier we spoke about the issue of planning, and I was raising the issue of if a district municipality wants to develop, to implement its IDP, it might be opposed by traditional leaders. And how difficult is this thing to negotiate around with traditional leaders when, especially people like yourselves who are involved in town planning?
Okay, thank you, Mshagazi. Let me start off by quickly responding to what Dr. Makhalimela has said before I move to your question. I just want to remind of a debate that was conducted on AM Live about a week ago, and where the president of Contralesa clearly stipulated to the country that no traditional leader owns the land, which is something which I find very strange in this whole discourse, because the department claims de facto ownership, while traditional leaders in the form of Contralesa are basically saying, retracting from that position, because this is a position which they previously held. Now, let me move on to your question. The question is quite a complex one when it comes to realities that we're faced with on the ground. Let me start off with where the source of this, the main driver that sparked the speeding up of promulgation of this specific piece of legislation. This arises out of the declaration of certain sections of the DFA unconstitutional. That having been done, the Department of Rural Development and Land Reform moved with speed with this piece of legislation. What we see on the ground is quite a bit of tension, a crack, let me call it a crack, between the metros and the Department of Rural Development and Land Reform on the one hand. The source of this is that the metros do not see the leadership role of the department. Why the Department of Rural Development in their space or in their midst? That's the first one. And the second one, which is a bit of a crack and an issue which is ongoing, is the tensions on the ground between municipalities and traditional leaders, which is quite widespread across all the former homelands in South Africa. There's very poor working relationship there. Now, going slightly deeper to that, if one looks at the structure of traditional leadership...
can we discuss that later? Because you have given us something to chew, and that is the tensions between the traditional leaders and the municipalities, especially around... Sorry, the municipality cannot plan properly unless they have an agreement with the municipalities. As I saw in the regulation, with the traditional leaders, as I saw in the regulation, there needs to be a service level agreement between the two. Do the traditional leaders understand what a service level agreement is?
We have taken the piece of legislation to the different houses of traditional leaders and also to Contralesa and also to provincial houses of a traditional authority, just to explain what this legislation is about and also their role as seen by the legislation. When we said municipalities and traditional leaders can actually form or come to some agreement in terms of the service level agreement, it was then to iron out if there are any disagreements between or a misunderstanding between the roles of municipalities and traditional leaders. Essentially, as I explained before, and as the Constitution confirms, this is a function of municipalities. But because the traditional leaders also are leaders in the communities, especially in the rural communities where there is traditional leadership, then we're saying it must be inclusive as far as possible of both the traditional leaders and also of the people living within those communities, which is why then we encourage that there be some agreement. In fact, even the Act itself, Section 23(2), it says these people must be consulted. It doesn't say may, but must. In other words, they are seen to be key participants or key stakeholders.
Which people are these? That is the local communities.
The traditional leaders, including also the communities there. Our government does recognize traditional leaders.
Let me just review from Namudisa. Namudisa, you've been listening to what we've been saying from the beginning of this program. The issues here are around planning and land use management, and we all know what kind of problems municipalities face. You've heard Siabulela Manona saying around the tensions between municipalities and traditional leaders.
Thank you very much. Well, you know, it's not just the department that recognizes traditional leaders. The Constitution recognizes traditional leaders. The Constitution starts from the point that we're one country and that we need to have a system that actually consolidates that, but also recognizes the different compositions of different communities. Where the problem becomes in terms of planning as well as a whole range of other legislation, and I know that we're discussing Spluma here, but it's important to also look at other underpinning principles and worldview that informs the government, that informs particularly the department and other departments, government departments, is that this usage of the word de facto owners of a land is not a casual usage in relation to traditional leaders and in relation to anybody else.
It entrenches something.
It reflects a thinking that runs through all the different pieces of legislation that the Department of Rural Development and Land Reform is coming up with. For example, let me finish. For example, on tenure, communal land tenure system, it says that land will be transferred to traditional leaders, right? even on section on Regulation 19 of SPLUMA, we see traditional leaders being taken as being involved on land allocation, right? Dr. Claessens asked a very important question earlier, say who represents people, right?
Let's get that answers. I have Khosi Mokoena on the line. Khosi Mokoena, good afternoon and welcome to Rights and Recourse.
Hi, thanks to Dumile and your panel.
Yes, I'm expecting you here.
Leadership, because out of protocol leadership, we had to respect the agreement we had with Dr. Makhalimele and the minister that they were going to have a meeting on the 23rd to iron out the exact issue that we're discussing now.
Okay.
But I feel it is imperative for us to put the record straight. With due respect to what was said by Aninka, I know Aninka from during Codesa. She was anti-Amakosi, anti-traditional leaders. Even now, we're not surprised what she's saying. Because can you imagine now if the whole kings and Okumkane in our country, when they want to develop their areas, they have to go and ask permission from a municipality. That is anti-African. I want to put it clear to me that as Amakosi, we are not against development. And we are agreed that there must be some agreement on how to use our land profitably, not to use it willy-nilly or just to sell land without getting permission from the owners who are the public. As Amakosi, we are holding land in trust. We're not owners, we are holding it in trust for the land. Now, with due respect to Aninka, I know she is happy that her queen in England, she's the owner of the whole land. She's not having any promises. But the question is, who is funding Aninka?
Chief Mokoena,
who is funding her?
Mr. Mokoena, I'm sorry. Chief Mokoena, we will get to some of the other issues.
He must withdraw that Aninka's Queen of England. Please, that's completely unacceptable.
Can I come in? The so-called specialists that we're having, some of them, we know some of them, they must tell us what happened when they were waiting in summit, because we want to expose them to some of these things.
Now Chief Mokoena, I'm sorry, I have to cut you short here. My apologies. I've got to cut you short here and come back to the studio because I wanted to ask you some more questions. But if you can stay on the line, I'll appreciate it and listen to the show because there are some questions I want to ask directly to you. But I want to come back to Aninka. Aninka, I don't know whether you want to respond for what Chief Mokoena was saying there, or do you want to add something to, I don't know, probably I must give you an opportunity to respond.
Well, just to say that I wasn't at Codesa, but the issue at Codesa was whether the Bantustans should be reincorporated into South Africa, into one country, or whether they should retain their independence. And at that point, you had an alliance between Mangope and the far-right Afrikaners, and you had an alliance between Inkatha and former Prime Minister, whatever the position was.
Dr. Claessens, I think let's confine ourselves to this issue. I don't want us to go back to Codesa because that's going to sidetrack us. Let's confine ourselves to this issue. The questions around the difficulties around planning and the fact that the chiefs have to go into discussion with municipalities, which is a burning issue here.
Yes, I mean, development is crucial. And everything should be done to ensure good working relations. The problem is we have an increasing trend of traditional leaders litigating against people, saying people may not have meetings, hold meetings, people may not represent the communities, because the only people who can do that are the officially recognized traditional leaders. So you've had a string of interdicts granted against ordinary people being allowed to represent themselves, particularly in the Platinum Belt in Northwest and Limpopo. So this issue of traditional leaders and the people, or traditional leaders in trust for the people, is actually disguising the fact that you have an absolutely far-reaching approach with traditional leaders litigating against their own people using traditional funds, saying that they are the only people who can call meetings and represent people. And that has a massive impact in the Platinum Belt and in mining disputes, where we've heard former Judge Jerome Ngwenya saying he doesn't need to consult people. The only people he needs to consult are traditional councils. So the question with this planning legislation is, will it be traditional leaders in an inclusive sense, including ordinary people, or will it be traditional leaders instead of ordinary people, cutting them out, as been happening with mining deals?
We'll come to those things. We'll come to those things. Dr. Claessens will come to those. Well, especially I wanted to focus on the Platinum Belt and other areas like the Kolobedi area in the Eastern Cape. If you'd like to join us on today's discussion, please call us on 011 714 5497 or 5498 or tweet us at Rights and Recourse or email us with your thoughts on Rights and Recourse at sabc.co.za. Stay with us.
From humble beginnings, this selfless icon altered the history of the world, freed a country, and united a nation. He taught us humility and forgiveness. To the world, he is Nelson Rolihlahla Mandela. But to us, he is simply Tata Madiba.
Welcome back, and here in the studio we're discussing this issue. It's becoming a very hot issue here in the studio if you take that call from Kosi Mokoena into account. Nobody, so you wanted to respond to some of the things Kosi Mokoena was saying?
Well, you know, it's a pity that whenever we have this discussion that there have to be different kinds of labeling. I think it's very clear.
And us and them talking.
And it's very clear that, in fact, Contralesa has a position on this that they've articulated very clearly. And it's very clear that what we are saying, or rather what the Constitution does...
Are you saying the House of Traditional Leaders is dominated by Contralesa?
Well, I'm simply saying Contralesa because they are the ones that I've heard, right? And they represent a certain section of traditional leaders. Where we all agree here, including Kosi Mokoena, that traditional leaders don't own the land, okay? We also agree here that traditional leaders have a role to play. What we are needing to clarify is what that role is, okay? Because even custodianship, okay, you can say that you are the custodian of your family, right? But you can also play that custodianship in a way that is not just and in a way that, in fact, appropriates the rights of other people. So these are things that I believe we need to have a conversation and try and understand what is it that the law actually say. That traditional leaders are not owners of the land in any way, right? In any way whatsoever. What they do is to have a role in relation to people who are part of their communities. So they cannot be involved in land allocation. Okay? But it doesn't mean that they cannot be consulted. And it's very important to say that they are not the only custodians or only people that are relevant in terms of culture and customs. If we want to go back to what Dr. Makhalemele started with, was that we want to build one country and one system of laws, and this is partly what this needs to be done. So we have to make sure that what happens in any corner of South Africa is consistent with an inclusive system and treating the citizens of this country and people who live here as equal.
Tell me if I'm wrong. All three of you can take a bite at this. There seems to be a school of thought that believes we can run two systems of governance parallel. One, a customary or a traditional set of governance, and the other one is the parliamentary, the government system. Can we do that? Can we afford to do that?
Okay. Let me just say that what I said in the beginning was that there are certain pieces of legislation that recognizes the existence of traditional leadership. In fact, they even have a house in Parliament. But we are saying this function of municipal planning belongs to municipalities in terms of our constitution and also even in terms of our act. We recognize that. Then we're saying traditional leaders together with their communities are key stakeholders in terms of rural planning. In rural areas, they must participate. Like all other citizens across the country, they must be part of it, and we recognize that. And in terms of the two systems now coexisting, we are just saying this function belongs to municipalities, but they can then form some kind of agreement on how they can then participate. In some municipalities, it's already happening, and it's happening well. But in some, maybe not, but maybe they must wait until they know how then they participate in terms of that municipal planning.
I just want to find out, that's where the crux is on this issue, Dr. Claessens, the issue of the law says this role belongs to municipalities. But what if the traditional leader says, I don't want you on my land. You're not coming onto my land. Let's take it, they say they own the land.
It's not their land. It is not their land. We need to be very clear on this. It is not their land. You know, there isn't a part of South Africa that is carved, that is said that this is the piece that belongs to the traditional leaders. It is not their land. It is the land of South Africans, of people who reside there in terms of the law. The rest, Dr. Claessens can respond to.
Dr. Claessens, you want to respond to that?
Well, I just want to say that I agree with Dr. Magalimelli that planning is a municipal function, and that wherever we live, ownership is limited by public purposes. So the municipality comes in and says you can't build a 6-story house here, or you can't have a butchery on this land because you're next to a school. So there, you know, throughout the world, this distinction between your powers as an owner and the duty of your municipality to plan and to moderate what you do is recognized as two separate things. One comes from your kind of rights to the land, the other comes from our society's right to plan and moderate what we do on land. So insofar as some traditional leaders, and most would never say that they own the land and the people don't own the land, but insofar as some claim that they are the rightful owners, it's very strange to me that they would then say, plus we want the planning power, because the ownership power is what's always regulated by the planning power. And I think really that this question of how we include all the different systems, including customary law, in a united South Africa is crucial. Because if we don't recognize customary land rights on their own terms, you would have no recognition of the ways in which black people have owned land despite racially discriminatory laws that stopped them having legal title. But it seems to me the mistake that we're making is that we're saying customary law applies only in the former Bantustans, and that's completely separate, subject to a completely different set of leadership from people in other parts of South Africa.
That's exactly my point. That's exactly
customary law throughout the country.
That's exactly my point. Can we run two systems simultaneously? But I want to go down to Eastern Cape, to East London. Siyabulela, the question is, government has said over around the issues, especially in the Northwest, in the Platinum Belt, that they want to revive mining towns. And these municipalities in those towns are frustrated by traditional leaders who are collecting royalties from the mines, and therefore they cannot do what they want to do. They cannot plan properly.
Yes. Thank you, sir. I think the point you're raising is quite a real one. It's not only in the platinum belt. The struggle over control over land is an issue that needs to be managed. And in my view, it's not an issue of a fault of legislation. There are possibilities and options out there to deal with that issue. In the Eastern Cape, for example, traditional leaders are fighting over control over resources, whether it's rental monies from Vodacom, Cell C, and various other networks. Not even mining. They're fighting for control over whatever mining, whether it's sabunge or whatever, or sand. I mean, that's how petty it can be. One of the critical issues that we're finding here is that municipalities are even stifling development in the process of this tug of war. They basically are using this notion of control over land to fight for additional powers. For me, that's not a fault of Spluma. That's an issue which we on the ground need to be finding solutions to some of these issues. The only difference between Spluma and various other pieces of legislation is that it has specifically mentioned traditional leaders as the sole stakeholders to be consulted. Whereas in rural areas, there are various other stakeholders that are there. In some instances, traditional leaders do not even have a following, while in other cases, traditional leaders are legitimate and have a following. All of these, a policy has to take all of these factors into account. Thank you.
That's it. If you'd like to join us on today's discussion, please call us on 011 714 5497 or 5498, or tweet us at Rights and Recourse, or email us your thoughts on Rights and Recourse at sabc.co.za. Stay with us.
Your World makes it its business every evening to round up the leading local stories and international news to keep you informed all the time.
Make a date with Your World every evening for all the news headlines around the world to keep you abreast with knowledge.
Catch Your World for headlines across the world every Monday to Friday from 9 p.m, then Saturday and Sunday from 7 p.m.
Welcome back to Rights and Recourse. To continue to discuss this topic, a rather strong topic that you've heard, if you've heard Koshi Mukwena phoning us from Nelspruit. Dr. Makhalimele, I know the problems that are in the northwest with the Bakatla, Bakafela, and all other countries. I'm told I must take a call from Kulekani from KZN. Kulekani, good afternoon and welcome to Rights and Recourse.
Good afternoon. Thank you very much for giving me this opportunity to participate in the program.
What is your question or your comment?
No, my comment is about the issue of land ownership and land allocation vis-a-vis planning, because as the doctor is correctly saying that planning is actually the municipal function. But let us separate planning and land allocation so that the role of leadership, of traditional leadership in terms of land ownership and land allocation should be separated from the function of the municipality as planning. So that to clarify the roles between these two part of
But
government.
Kulagani, the municipality cannot plan if they do not have access to the land.
Yes, as I'm saying, yeah, I agree with that. I agree. They cannot plan if they don't have access to the land. The problem here, maybe if I may say, inkinga enkulu esinayo eyokuthi na the traditional leaders have power over land, and they always think planning by the municipality is there to take their power from them. It's not about helping them, so that as they allocate land in a planned manner, so that whenever the municipality want to even provide services.
Thank you very much, Kulagani. Thank you. You've given us something to chew. You've given us something to chew. Isn't that the crux of the matter? That the traditional leaders somebody should explain to them. The municipal function is for you to be able to better do your service delivery to your people as a traditional leader.
That is correct. But what the SPLUMA provides for is that during the planning process, all the stakeholders must be involved. They must participate, because after all, in the planning process, then there is a priority of needs that must be taken on board, which then must come from bottom up by the communities themselves, because they need to express what it is they need more than the other. And during the cycle of planning, then you can prioritize certain things that need to be provided by the municipality. And in terms of one of the municipal functions, also again in terms of SPLUMA, municipalities have to come up with plans, wall-to-wall land use schemes, in other words, zoning, what this little piece of parcel will be used for, and against the other, and the next, like that. So then whatever happens there in terms of activity must be in accordance to that particular plan.
That particular plan.
Yeah.
I agree with you. That's an ideal world. Nobody saw. I watched a documentary last night on television around this very issue. It was dealing with the issue of Kolobedi, where the people of that area had agreed they don't want mining in that place. But the chief went and joined the people who were forming and BEE to be part of the people who wanted to do mining, the chief in that area. That's what happens on the ground.
This is where I think it's very important for the department and every arm of government to be clear and unambiguous about what is the role of traditional leaders, what is the role of people who live in these communities. Because if, for example, we come up with a system where one sector of community is elevated over the other, people's voices are not heard, irrespective of whether we say it's going to be bottom-up. People with interest, financial interest, make decisions ostensibly on behalf of communities, but actually for their own benefit. And we see this in Kolobeni, we see this in Northwest, we see this, in fact,
in Northern Cape.
In fact, even in Ngonyama Trust Act, right? That land is supposed to be belonging to people of those areas.
Can you hold your thoughts further? Yeah. I want to take this call from Zwandile from the Eastern Cape. Zwandile, good afternoon and welcome to Rights and Recourse.
Thank you very much, sir, and also to your guest. You know, I actually caught the program halfway, but I'll make my one or 2 points. Uma Munomboniso made a very vital point, and that is, you see, the problem that I think is we rushed too quickly after 94 to formalize in South Africa, to include the former homelands without necessarily doing an intricate engagement and consultations with those people. because
the
fact must be faced. We as South Africans, especially I'm from the Eastern Cape, because we have a certain understanding of history and the relationship between history and royalties and the ownership of land historic in this country, even before 1652. So we hold a particular view about land ownership, and now you're now seeing various doctrines that are beginning to surface, which are contesting what has been publicly known. So, I think a consultation has not really happened to consult in a respectful manner these former traditional owners as well as their people in terms of what are we knowing about history? And okay, now that we are where we are now, where things are democratic and people must have a right to own land, even under traditional leaders, how then do we transition traditional leaders into the new dispensation in a respectful manner and their role to be clearly defined?
Thank you, Mzondile. Thank you very much. Mzondile, thank you very much. We quickly have to go to the markets. If you'd like to join us, you can do the same as Mzondile and call us on 0117145 5497 or 5498 or tweet us at Rights Recourse. Stay with us.
Several thousand migrants are adrift in boats in Southeast Asian seas.
The refugees have been abandoned at sea by human smugglers with little food and water.
The UN has appealed to the governments of Thailand, Indonesia and Malaysia to act quickly to avert a massive humanitarian crisis.
Leaders will meet in Dar es Salaam on Wednesday to discuss the political crisis in Burundi.
At least 19 people have been killed and more than 200 wounded during violent protests against President Nkurunziza's bid for a third term.
Primetime News, daily at 6 p.m.
Welcome back to Rights and Recourse. As we finalize or closing this topic, it's been a very difficult topic to take through to discuss. Yeah, Nombundisha wanted to say something earlier. I cut you short when I wanted to speak to Mzondile.
No. It's part of the conversation that I think has to continue. That when when you look at what is considered to be custodianship and the agreements that some traditional leaders, not all of them, make in relation to the wealth of their communities or the wealth that belongs to everybody in those communities, you find that people are in fact excluded, and yet they have to live with the consequences, the negative consequences of whatever that is happening. And part of it arises from this hierarchy that we have inherited and that we are reproducing, that certain categories of people in communities have a right to be heard and to be listened more than others. For example, for me, what is interesting about the Spluma debate is that in the National House of Traditional Leaders said to government, to the minister, checkmate, this is not going to happen in our area, right? And you have the minister responding, says, but you are de facto owners of the land. But most importantly, you also have to take it back further. You have the minister saying, we will amend that. We will amend a certain regulation because we've heard them. Now, if you just look at the power relations there, and in terms of who is being heard in this democracy, it is very perturbing because you have communities that have been saying for so many times to different ministers, including Minister Nkunti, on a number of issues that this is not going to be appropriate for us. We don't want it, and these are our reasons. And they're not listened to. So as long as you have these differences in terms of who's being heard and who's led to believe that they're being heard, and who is led to believe that they are not being heard, you're going to have these tensions.
Dr. Makhalimela, do you want to respond to some of the things that were raised? Apparently, I also heard the traditional leaders I spoke to over the weekend, and I think Khosi Mokoena did mention it, are banking on the fact that there could be amendments to the Act or the regulations.
It will be really difficult for me to respond on behalf of the minister, because this discussion now is at that level. And as nobody so correctly states, he is consulting them, and they have in fact invited him to talk on this issue with them. So I think that it was just a response from our minister to an invitation by the National House of Traditional Leaders. So I'm not in a position to preempt that discussion.
The question I wanted to ask you quickly is, I understand there's going to be a planning tribunal. Who is going to be serving on this planning tribunal?
Oh, the people that are going to be serving, remember we said this function belongs to municipalities, yes. But then it will be the officials that are employed within the municipality, and also other experts that can be appointed by the municipality themselves when they find that they don't have that expertise within the municipality itself, like engineers, like environmentalists, etc., etc., but primarily planners.
A few seconds we have. Dr. Aninka Classes, you can make your closing remarks.
You know, I just want to say that it's very heartening that people in Controlesa have always said, actually, that the people own the land. They've always said that traditional leaders are subject to layered decision-making processes. And it's wonderful that Khosi Tobejani reiterated this recently. And I think that the traditional leader lobby, which goes for the opposite approach, saying that only traditional leaders can actually speak on behalf of rural people, is doing the institution as a whole a massive disservice. And I think the minister too, in saying that traditional leaders are the de facto owners in order to try and placate them, is really not being honest with traditional leaders, because the Constitution is clear that their powers are subject to customary law. And
let's leave it there, Dr. Classes. Let's leave it there. We're going to have to discuss this at another time. There's a whole lot of things that are a boiling pot around this issue of customary law. This has been Rights and Recourse. This program is repeated at 10 tonight and at 5 on Monday morning. In our next show, we are looking at bringing you a discussion on the law of succession, customary law of succession on Rights and Recourse. We would appreciate you sending your comments and views on this issue to Rights and Recourse at sabc.co.za. You can also tweet us at Rights and Recourse. We are looking forward to hearing from you. For now, let me thank our studio guests for their time. From all of us here in the studio, it's goodbye. Good evening.